I are doing the forward-looking slots, and I've got the joy of presenting to you about GDPR, which I'm sure is something that is absolutely top on your list, and you're probably really looking forward to this. What I want to do today is I'm not going to focus on the regulations in their entirety, I'm pleased to know. I'm going to really focus on what's important for you as HR professionals. What do you need to know when you're advising the business? And the slightly good news that we have in the UK is that actually we are more advanced than our counterparts in mainland Europe, because we have the benefit of the original Data Protection Act in 1984 and obviously the amended Act that came into force in 1998. So I think the starting point is that if your organisation is generally pretty compliant with that Act, hopefully it won't be such a huge piece of work for you to get ready. But having said that, there is still quite a lot of areas that you need to focus on. And I know that for some of the businesses that I've been working with already on this, there's a lot to do and a lot of planning and processing and thinking about how these regulations impact on what you do and the management of your employee data. One question that I'm always asked is, why is it a regulation and not a directive? Because lots of you will be thinking, from your CIPD days, CHIP is a directive, we have the Acquired Rights Directive, lots of the EU stuff comes through as a directive. And the simple answer is that the EU decided that it's important for business consistency that every country across Europe is working to the same set of standards. And that's why we have a regulation, because that would literally be, provided we're a part of the EU, incorporated in our national legislation without deviation. There are some slight areas of deviation. But to be clear, the government has decided that it's so important for our sort of trading post-Brexit that we are operating to these same standards, that they are at the moment passing the data protection bill, and that's going through Parliament at the moment, and literally what that's doing is replicating the principles of the regulation onto our statute books. So post-Brexit, you'll still be expected to comply with these principles. Now I'm going to start. I'm conscious that we've been sitting around. It's I hope it's not too cold for people, but we're sort of lots of listening. And I'll start by asking you all a question. And the first question, you should have in your pack a yes or no card. And I'm going to ask you, how many of you, if you're aware of this, are currently aware that your organisation is processing HR data relying on consent? No trick answer, it's just literally to get a sense of brilliant. Okay. Currently, yeah. So I think that's amazing. Pretty much is the sea of green. I think there's a couple of red patches, and that's exactly what I predicted or would have predicted, because most businesses, if you look in your employment contract, I'm pretty sure they will have a standard clause saying, we are processing you agree to us, employer, processing your data for these processes. And the bad news is that post-May next year, you won't be able to do that anymore. So that's one of the key steps that you're going to need to think about as HR professionals, is looking at your contracts of employment. Because the regulations themselves are very clear that you will not be able to rely on consent if there is an imbalance between the data subject and the controller. So the starting point is that the regulations themselves are very clear that if you've got that imbalance, you can't rely on consent. But the Information Commissioner has actually gone further than that and has said that if there is, for consent to be valid, it has to be freely given and that the individual can withdraw it at any time. So obviously that's a disaster for you if you're managing an employment relationship, because you really don't want to be working in a scenario where any one of your employees at any point can say, I'm sorry, I don't consent to you processing my data anymore. So what do? Well, luckily or helpfully, there are some very useful conditions set out in the regulations which will apply to pretty much most of the data that you are processing. And the starting point is that if you are required to process data to comply with a contractual obligation, then that's okay, provided the individual knows what you're doing. And so obviously all of you will have a contractual relationship with your employees. and you will be doing things like paying them based on that contractual obligation. So that enables you to process some data. The second area that you can rely on is legitimate interests. Is it in the legitimate interests of your business that you're processing the data? And something that may fall within that category could be monitoring. And the third area is compliance with a legal obligation. So if, for example, you're transferring data under a TUPE transfer, the employee liability information, you're doing that because you're legally required to do that. So under the provisions, it's okay, you're lawfully allowed to transfer that data. But also, as employers, you're not just processing personal data in the usual sense. You will always be processing, or often processing, what used to be called, or is currently called, special sensitive data, and is now going to be called special categories of personal data. And that includes information like information about people's illness, their health records, their gender, race, all of those sensitive categories of data that you need to get, at the moment, express consent to work with and to process. Your obligation or your ability to process that data is not going to change, but you do need to look at those three conditions that I put up on the slide and make sure that your processing is falling within them. And hopefully the second condition on the slide is that it's necessary to assess the working capacity of the employee. So if, for example, you're getting health records or occupational health records, that obviously your ability to use that data falls within that category. So I think, as I've shown, the first step that you need to think about is the basis, the type of data that you've got, what you're using it for, and then obviously looking to your contractual documents because you're going to have to update them. In addition, though, to your contract, you need to start to think about your processes and procedures. And some immediate points that you need to consider are, not only are you going to be processing data about your current employees, but of course you'll be processing data from job applicants. And they will be entitled, just as much as your current pool of employees are, to make sure that they have the information that's required under the regulations about what you're doing with that data. And that's called the fair processing requirements. So in very simple terms, what you're expected to do is to tell them what data you're going to collect, what you're going to do with it, how long you're going to store it for, and their rights and their ability to take action if you act in breach of the regulations. There's also, I'm conscious that lots of you here may use automated processing to make employment decisions, and this is really common again in recruitment. So, for example, there's some law firms in the audience, and I know that often law firms will select employees based on a minimum level of grade. And certainly for some larger firms, what they do is they'll have an automated system whereby people apply for a job online and the computer basically rejects anyone who hasn't got, say, a 2-1 degree. And that's just a decision that's happening. And those type of automated processes are happening more and more in the HR context, in particular in the field of recruitment. If you are using those type of processes, you'd absolutely need to signpost that to the job applicant. And they need to be aware of the type of decision that's going to be made and given an opportunity to complain or to raise objections about you processing their data in that way. So if, for example, someone didn't get a 2-1 degree because they were unwell or there was some underlying reason, they should be entitled to make representations to you, and then you would be able to take that into consideration when you decided whether to offer them the job. In addition to the processes and procedures, the rights that your employees will enjoy are also going to improve under the new regime. They will have a right to retrieve the data that you've got about them, to ask you to rectify it, to ask you potentially to delete some data, and I'll come on to look at that, and also to restrict what you do with that data. And looking at employees' rights, my second question is whether anyone here has recently or ever received a data subject access request from a disgruntled employee? Yes or no? Right. And again, I think that's probably a little bit more evenly balanced, but I would say that the yeses probably still have it. I think the reason for flagging that is that certainly it's a tactic that's used more and more in litigation and pre-litigation as a way to put pressure on businesses to try and settle, and also, obviously, to reveal that smoking gun document. And the bad news is that post-May next year, the regime is changing, and it's actually becoming much more easy for employees to bring the request. There is no need for them to pay a fee. At the moment, they only have to pay £10, so it's not exactly punitive, but I've found in experience it often sort of delays the process because people forget it and you can sort of ask for a little bit more time to deal with things. Your only ability to charge a fee is if the request is so extreme, it's viewed to be manifestly unfounded or excessive. And at the moment, the jury's still out as to exactly what that means. But I think it's going to be a very, very small percentage of cases. And you're going to be quite nervous, I think, to ask people to charge a fee because of the rights that individuals will have to make a complaint to the ICO if you don't comply with the request. The really bad news is, though, that your time limit for complying is going down from currently 40 days, which is still, I think, incredibly tight, to 1 month, which is really going to be quite tough, I think, especially because in the employment context, so often what you're looking at is looking through realms of data, and often a lot of what's in there is dealing with other employees or potentially stuff that's commercially sensitive. So the really big job is not necessarily pulling the data off your system, but to actually redact it. And I can see some sort of nods of recognition there in the audience. And certainly we've had some huge cases over the years where we've had teams of lawyers working around the clock, sort of reading through various documents to understand what can and can't be disclosed. So that time period is going to be tight. And as I said, you can ask for an extension, but it's going to be in the limited number of cases. So people need to know, they need to understand. So I think the practical advice post-May next year is obviously, if you do get a request, you can't just sort of sit on it for a little bit. You have to really action it quickly. You need to review the scope of that request. And if there is any question mark at the moment about how good your systems are for accessing data, then you need to look at that and make sure that they are updated accordingly. One of the interesting things that's sort of been snuck in as part of the new regulations is this new right to be forgotten. And this actually was introduced not with an employment agenda at all. It was introduced as a way to require the big search engines like Google to take down information about individuals that they felt was inaccurate. So you remember there's been some quite salacious cases over the years, and there's been satellite litigation against Google. And off the back of that, the regulation has included this concept that if there is something that's inaccurate out there in the public domain, the data controller has to remove it. Now, I can see that that will have an implication potentially for employers, because in reality, what you often have to think about is, so think about if you're given a written warning, how many of you, and you don't have to show of hands for this, how many of you actually, if you're honest and you think about it on your file, probably would keep that written warning after it's expired? My experience is often looking through files, it's there. I think employees will potentially, if there's any sensitivity about that, we may start to see clued up lawyers coming to businesses and saying, right, it's a year and a day, that's got to go. And unless there's a legal reason, there are some conditions where you can say, yes, I need to keep it. You would be expected to delete it, and to delete it irretrievably. Internationally, I'm conscious lots of you work in global groups, and you will be transferring data around the world, potentially relating to your employees. The good news is that actually the regulations aren't really changing the restrictions that you have about that. And if anyone's got any questions, I'll happily take that at the end. But what you do also need to think about is that if you have, say, an American parent that in theory doesn't have a footprint in the UK but is trading here or offering goods and services here, then any data that they pass into the UK will still be subject to the GDPR regulations. So it does have that sort of extraterritorial effect. Breaches. Now, this is something that's actually much more of an issue. The requirements are going to be really tight. So if you become aware that your organisation has breached the principles underpinning the GDPR, the expectation is that you have to tell the ICO ASAP and not later than 72 hours of the breach. So you can see, so for example, the recently reported Uber case that came out last week, they sat on that news for pretty much a year, didn't they? They were hacked in 2016, sat on it, and then it's only just very recently come out into the public domain. If you were, heaven forbid, that you were ever in that scenario but your business was hacked, or even if you were in a scenario where one of your senior employees leaves a laptop on a train and it contains sensitive data or data that could be personal data, the expectation is that from May next year you would have to tell the ICO really quickly. And that also has a trigger effect because for many sectors, so for example law firms and even financial approved, so firms that are regulated by the FCA, there's also a suggestion that because you're potentially committing a regulatory breach, you have to tell your own regulator, so the Law Society, the SRA or the FCA. And as I'll come on to show, you'll need to tell your insurers because potentially the impact of that breach is going to be quite significant.
Sorry,
Yeah.
Very quick question. We say no, 72 hours. Is that 72 hours after the breach or after you become aware?
It's 72 hours of you becoming aware of it. So, but I think the expectation is that you'd have quite tough processes, so you should hopefully know about it quite quickly. But I can see that that's definitely going to be an area where HR will be involved because obviously you tend to be at the forefront of managing those kind of issues. You would be expected to keep a data breach register. Interestingly, the obligation to notify the regulator is really tight, but the obligation to notify the data subject, so the person whose data has been sort of transmitted in error, sent to the wrong place, has been lost, is actually not quite so tight, and you only have to the obligation there is to do it without undue delay. So that 72-hour limit doesn't apply to them. So I think that's quite an interesting distinction there. And I'm going to end with just to look at the fines, which is really the stick that the regulators have decided is so important and to really highlight this issue to make sure that there is compliance. The headline, I'm sure everyone's aware, is that if you were to be fined for primary infringement, then it's potentially 4% of your global turnover. A secondary infringement is 2% of global turnover, or the amount in euros, whichever is greater. So for some global groups, it's going to be hugely significant. But interestingly, and this is something where I think we're going to see potentially in our space more work, is that it's also opening the door for group claims. So for example, all the Uber passengers whose data was hacked, the TalkTalk customers whose data was lost last year by TalkTalk, they could get together, bring a group claim and claim compensation. And I think you'll have seen the headlines about Morrison's losing its pay data. You could well see that a group of your employees whose data was lost could get together and potentially there would be satellite litigation. So what do you need to do to get ready? Well, you've got just under 6 months now. And I think if you haven't done it already, you need to have set up a project team. I think HR has to be at the centre of it. You can't, it's not something that you can, I'm afraid, avoid. But also, you need to get your colleagues from IT, obviously marketing, procurement, legal. It's a group effort. It's a team sport, I think, this project. You then need to think about undertaking a readiness assessment and look at those areas that I've flagged up. What sort of data are you processing? What systems are you using? What do your contracts say? How do your policies look? What do you need to start to update and amend? And then, obviously, you've got next year to implement. So you need to look at your contracts, you need to look at your policies, you need to think about potentially staff training. If you haven't got one, you may need to appoint a DPO. And certainly we've worked with some organisations to help them sort of look at what skills are needed and who's the right person. Most people are recruiting internally for that role. And I think that probably if you need to go externally now, it's going to be quite tight to find a good person before May. And also you need to think about how you're going to cope with breaches, your incident response plan, what will you do, and make sure that managers are aware.